Good afternoon, everyone.
Good afternoon, sir.
Hi, good afternoon. So, I'm Nitin Saxena, and I welcome all of you to this virtual platform of Knkr DHL Memorial Trust. Okay, so today I would like to give you some facts as per the data which is available on the internet. That is, in the year 2022, the Indian legal profession consists of approximately 12 lakh advocates, and approximately 4 to 5 lakh law students are there across the country. And every year, approximately 60 to 70,000 law graduates join the legal profession in India. So the main point is, out of these 60, 70,000 law graduates, how many actually become good advocates, and they actually learn all necessary things which are required when they go through all these law graduation during this law practice. So according to American Bar Association, about 36% of all the attorneys say that they are very successful, and half of them actually indicate that they are successful. Now, if we compare this ratio with Indian advocates, then it is actually much less than what should be there, because of the fact that the fresh advocates are not aware of the basic fundamentals of practice at court, and no one is there to make them learn and understand all these of this profession, to learn and make them understand all these things, right? So, but it doesn't mean that the fresh advocates are not aware about law. The main contention is that theory is totally different from the practical knowledge that is practiced at court. And hence, to resolve this problem of fresh law graduates, fresh lawyers, law graduates and fresh lawyers, KNKR, the HL Memorial Trust presents Foundation Course Batch 2 on basic knowledge of court practice for final year law students and fresh graduates. So this program actually contains, it will cover the topics on dressing sense, client dealing, file management, court presentation, diary management, and legal performance. And the main point is that the training will be provided to you by the experienced practicing advocates. Now I over this to Advocate Bhanu, please.
Hello, good afternoon, everyone. Myself, Advocate Bhanu Kasan. And I again welcome you all in second training batch of Foundation course of Basic Knowledge of Court Practice, organized by KNKR, the HL Memorial Trust. I want to introduce Ms. Priyanka Aneja, advocate, who will take us to the session on dressing sense of advocates. I would like to introduce Ms. Knkr advocate. However, I will not take too much time. I'll introduce Knkr advocate, and his past is LLB in 2017 from Chaudhry Charan Singh University, and he's completed his LLM from Jagannath Institute of Management Science in Criminology in 2022. And she's engaged in activities including social work services in national. She's a national president in Women's Cell Department, Corruption Control Organization, and the legal advisor in support, care, and community. Now, I would like to introduce Ms. Priyanka Aneja. So it's up to you, ma'am. Please welcome Ms. Priyanka Aneja. Hello.
So much,
please.
Manu. Thank you so much, Rakhi Budhiraja ma'am, for giving me an honor to the discussion of courts. So basically, you must be aware of dressing sense of a court. आपको पता होगा कि Supreme Court, High Court, District Courts में the black and white is a mandatory dress color we wear. Supreme Court or High Court, you are allowed to wear a gown as well as a mandatory outfit. So basically, dress code is a symbol of confidence, a symbol of discipline, and a symbol of profession. It's basically a proud part of individual personality. आप लोगों ने कई बार देखा होगा कि आप लोग कहीं ट्रेवल करते हो तो कुछ लोगों की आपको यूनिफॉर्म्स या ड्रेसिंग सेंस बहुत अट्रैक्ट करता है। बेसिकली वो जो है आपका एक जो डेकोरम है वो मेंटेन करने के लिए होता है, एंड दैट्स व्हाई लॉयर्स हैव अ ड्रेस कोड। तो आप लोगों ने कभी सोचा है कि व्हाई उनकी ब्लैक एंड व्हाइट? कैन एनीवन आंसर कि ब्लैक एंड व्हाइट की ड्रेस कोड क्यों है? Basically, black and white is a symbol of a legal profession throughout the world, bearing few expectations. Black color generally has so many different overtones, like every color has both positive and negative connotation. So on one hand, it signifies death, hell, evil, and a mystery, while on the other hand, it signifies the strength and authority. So basically, black color was chosen for out of two reasons. The first was colors and dyes were not readily available back then. So, and the purple color was signified as a royalty. So the amendment fabric color left was black. However, the main reason behind wearing a black coat is because black is the color of authority and power. Black represents submissions of oneself, just like priests black to show their submissions to God. We advocates, lawyers wear black to show our submission to justice. Like आपने देखा होगा कि कहा जाता है कि सफेद कोट और काला कोट क्यों पहना जाता है। सफेद कोट होता है कि जब आपको हेल्थ इश्यूज होते हैं तो आपको हेल्थ प्रोस्पेक्टिव से सेव करते हैं, बट ब्लैक कलर, ब्लैक द एडवोकेट्स आर व्हेन यू आर इन ट्रबल, they are there for that. They are your last hope to fight against and to help you get justice in your whatsoever the concern is. And why we wear a white color? Because the white color signifies light, godness, goodness, innocence, and purity. As a legal system is the only hope of justice for a common man. Like just I said कि एक common इंसान के लिए, day to day person के लिए, we advocates are the only last hope जो उनको justice दिला सकते हैं, जो उनके साथ गलत हो रहा है उसके लिए. That's why the black and white color was chosen as a advocate's uniform. And moreover, आप लोगों को किसी को history पता है of white and black? Can anyone there who wants to tell me about the history of white and black? Okay. As the Indian system is influenced by the British rulers, due to their region, the Advocates Act of 1961, yes, the Advocates Act of 1961 makes it mandatory for the lawyers to wear a black robe or coat with a white neckband on top of it in the continuity of the same. So you must have seen all the advocates wearing a white shirt, black pant with a black coat and a robe of white color in their neck. And if you visit a Supreme Court or you have seen an advocate in Supreme Court, they are wearing a gown over it. So it signifies the color also. So this white and black also highlights the law is blind. Yes, say that it is based, differentiates on the weightage of evidence and not on any other further facts. So black and white is like कि आपके लिए कोई मतलब कोई अलग कलर या कोई डिफरेंशिएशन नहीं हो रहा है. It's on totally based on the evidence. Doesn't mean it's basically totally depend on evidence. आप लोगों ने देखा होगा white color neckband. Basically, the white color neckband to have their origins rooted in England. In the old English courts, the barristers at law used to wear that white bands as part of their uniform. Since the barristers were the first lawyers of Indian courts, their dress was adopted as a symbol of advocates in our country. And so we wear a white neckband. The two pieces of white cloth joined together to form the advocate's band represents the tablets of the laws. The white advocate's band represents the upholding of the law of God and a law of land. So if you are an advocate or you are recently enrolled, wearing a neckband is mandatory in courts. So the regulation, as per the regulations of Bar Council of India, as per section 49 of the above rules, governs the dress code for the advocates appearing in the Supreme Court, High Courts, subordinate courts, tribunals, or authorities. They shall be wearing as part of their dress, which shall be sober and dignified. Most of you have seen, and most of the times, ki the first appearance of a person, आप जिसको भी देखते हो, the first which is appeals to you is their uniform, the outfits they are wearing, not just uniform or even there are any other outfits. अगर कोई अच्छे कपड़े पहन रहा है, if he is well dressed, you like to go and talk to them, and that's how the advocacy as well works. You are not wearing your proper dress code, you are not in a dress code, so no client will come and consult you. Yeah, they will avoid to get in contact with you. Dress code for advocates India, you can read about it in part 6, chapter 4 of Bar Council of India rules. Under section 49, subclause 1, GG of the Advocates Act 1961. A coat, black buttoned up coat, chapkan, achkan, black sherwani, and white bands with advocate's gown. A black open breast coat, white shirt, white color, stiff or soft, and white bands with advocate's gown. Is either case, wear long trousers, white, black, striped, or gray, or dhoti, excluding jeans. Secondly, you can wear a black tie. Most of the interns or newly enrolled advocates wear a black tie as well, though you are not allowed to wear it in Supreme Court. Provided further that in courts other than Supreme Court, High Court, District Courts, Session Courts, or City Civil Courts, a black tie may be worn instead of pants. But it's usually happens when you are an intern. So there are few dress prescribed in subrule B for lady advocates as well, whereas a black full sleeves jacket or blouse, white collar, stiff or white, soft with white bands and advocates gowns, you can wear that. White blouse with or without a collar with white band and a black open breasted coat you can wear. Saris or long skirts, white or black or any mellow or subdued color without any print or design. It should be simple and sober. Or flare dress you can wear, which should be in black, white, or black stripe or gray color. Even if you are wearing a Punjabi dress, churidar kurta or salwar kurta with or without dupatta, it should be in black and white, or means whatever you are wearing a coat, it should be in black, white, or in a gray color with your neck bands. Apart from that, you must, there is a recent judgment, not a judgment you can say, but a Supreme Court judge, Indu Malhotra, has said to women that no palazzo pants, just dress for professionally. Yes, in a sea of black, women lawyers at a Supreme Court stands out in pop of colors, right? Restrained by the prescribed dress code of black and white. Some women advocates express their fashion sense through their handbags, watches, and bubbles, which includes rings, watches, earrings, and makeup. However, the newest Supreme Court judge, Indu Malhotra ma'am, expressed her reservations over the casual attitude of young women advocates towards their attire. You must be professionally dressed up, no matter in which court you are. Ms. Malhotra shared her dislikes for palazzo pants and 3/4 trousers in particular. Even though these pants fitted at the waist, loose towards the hem, are chic and casuals, perfect for the hot Delhi summer, they do not really fall under the category of professional attire. Like wearing a palazzo pants, 3/4 trousers, or a tight clothes do help you out in a when you go out in summers, and it looks good, but actually it doesn't comes under your professional attires. And being an advocate, you should be professionally dressed up all the time. Okay, and advocate's gown, you must be aware of advocate's gown. You must all have seen wearing an advocate a black long gown. It's mandatory in Supreme Court, and in High Courts, it's mandatory to wear in winters, whereas you can avoid wearing it in summers in High Court. But yes, whenever you are appearing in Supreme Court, whether it's summer or winters, you have to wear a gown. It's mandatory. You can't avoid and just go like just wearing a coat and appearing in court. No, that doesn't justify or being you are fully dressed for your court cases. So what are the exemptions of wearing black coat? Well, except in Supreme Court and High Courts, during summers, wearing black coat is not mandatory, like just I said. In Rule of Chapter 4, Part 6 of the Bar Council of India rules, it is clarified that so far as the courts other than Supreme Court, High Court are concerned, during summer, while wearing black coat is not mandatory, the advocates may appear in white shirt with black or striped or grey pant with black tie or band and collars. So you can appear in gown. It's look good, but in summers, if you feel really hot, you can avoid wearing it in high coat. So dress code in public domain. Okay, you must be aware of it that being an advocate, wearing a gown and a band, you can't just roam in a public area just like you are going for an outing, and no, that doesn't come in professional ethics. As per Rule 7 of Chapter 2 of Bar Council of India, an advocate should not wear bands or gowns in public places other than in courts, except on such ceremonial occasions and at such places as the Bar Council of India or as the court may prescribe. If you are going for an outing or with your friends or going for a lunch or just going for partying and all, you are not allowed to wear your bands and you are just roaming like, no. Even if you are going from a court, you should not wear bands. You must remove the bands before exiting the court premises. So there is a judgment by R. Muthukrishnan versus Union of India. Yes, it's R. Muthukrishnan versus Union of India. You almost can go
Excuse me,
through it.
I just cannot hear
Both said
anything.
constantly-
There's no audio.
Hello, am I audible to everyone?
Yes, ma'am.
You're
Yes,
Very
ma'am.
clear.
Yes, ma'am.
So,
Sir, I think one person is there who is stating that there is no audio. Please, sir, please check at your end, because everyone is going through the lecture delivering by the Priyanka as an Asia advocate. Nagesh, sir, please check at your end.
can I start with the judgment?
Yes, continue,
Yes,
Priyanka.
ma'am.
Sure, ma'am. So the R. Muthukrishnan versus Union of India judgment, the court have constantly maintained that advocates are supposed to wear their gowns and bands only during the exercise of their professions, which means only when they appear before the courts, not when you are roaming outside or when you are not in your court premises. In R. Muthukrishnan versus Union of India, an advocate had filed a public interest litigation, that is PIL, as a petitioner before the Madras High Court and wanted to appear in his case wearing a band and gown, where he argued that he was an enrolled advocate, hence was duty bound to wear a band and gown while appearing before the court. The court held that when an advocate appears as a litigant before the court, he does not exercise his right to practice throughout the territory of India, which is enshrined under Section 30 of the Advocates Act. The court further held that the practice here means exercise of profession, and when an advocate appears as a litigant, he does not exercise his profession and hence cannot wear a band and gown. So if you are just appearing in your band, it is not mandatory that just because you are your self-advocate or you are just filing your petition or you wanted to deal with your case, you can wear a band or gown. No, you cannot. The court reached a similar conclusion in T. Venkana versus the Honorable High Court of Mysore. It's T. Venkana versus the Honorable High Court of Mysore, and MCS Barna versus CB Ramamurthy. It's MCS Barna versus CB Ramamurthy. In Barna, the court reiterated that an advocate could wear his gown and band only when he is practicing his profession. Interestingly, this practice of strict adherence to wear a band and rope goes back to colonial days. It is believed that the Chief Justice of Allahabad High Court, Sir John Edge, was once hearing a case for withdrawal of winding up of proceedings from the district court to the High Court. One Mr. Query was the official liquidator and appeared in person to oppose the petition. Mr. Query was dressed in robe and began to address the court from the advocate's table. Yeah, the table from which ordinarily advocates address the court. Chief Justice S is believed to have remarked that in future, whenever an advocate appears as a litigant in person before the court, he must not address the court in robes and from the advocate's table. These remarks from Chief Justice S was considered to have stated this practice, which is the law today. So there are one of the observations from Bombay High Courts in Jain Adalat versus State of Maharashtra. In light of the law discussed in this observation is clearly that advocates can only wear a robe and band while appearing in courtrooms and nowhere else. Like just I said, if you are appearing in court, only then you can wear your gowns and robe. If you are going out somewhere, you are not allowed to wear. It's actually unprofessional. Therefore, if an advocate gives an interview to the media or appears on social media in this attire, he and she is violating the law. If you are appearing for any interviews on social medias, even though being an advocate, you can't appear wearing a robe. This conclusion is also supported from the Bombay High Court's observations in Jan Adalat versus State of Maharashtra, wherein the court is an obiter dicta remark that members of the bar, while visiting their clients in prisons, must remove their bands and gowns during such meetings, since a failure to do so would violate the rules of professional ethics governing advocates. Yes, you must keep in mind that while you are appearing or going to the prisons, meeting your clients, still over there you are not allowed to wear your bands. It's actually you are violating the rules of professional ethics. The relevant observations read, moreover, the rules of professional ethics governing the advocates regarding that the bands and gowns should be worn only in the court premises. So I guess you all will remember that you must be wearing gown and a band on robe only when you are appearing in court for a case matters or if you are in a court premises, not outside that. Nearly to be followed. Generally, I am used to see lawyers after getting free from court proceedings, like just I said, used to walk on roads while wearing band and gown, travel in metro, going from one place to another in autos and cabs, which is unethical and against the rules of Bar Council of India. Need of the time is the rule made by our Bar Council is to maintain the dignity of advocates and the royal profession of advocacy be followed by the advocates. We should not forget that if we will follow and if we will maintain our dignity being an advocate, only then the common man or the people will respect our profession. Thank you. Hand it over to you back, Mr. Bhanu. That's all from my side. Thank you.
Thank you very much, ma'am, for giving this deep knowledge about the advocate's dressing sense. And the session was very informative and interesting, ma'am. And thank you very much.
So much. If anyone has any queries, they can ask.
Yeah, sure. Now I would like to introduce Rakhi Budhiraja, ma'am, who is mediator in the Supreme Court of India, and who is mediator in the Supreme Court of India and the mediator at National Consumer Dispute Redressal Commission, and the trained mediator by IP Assisto, and trained post trainer by ProTouch, trained arbitrator by Acromic Point, certified post trainer by SHRM, trained post trainer by SHCI, certified post trader by CHRD, and the panel lawyer at HDFC Bank, panel lawyer at Punjab National Bank, panel lawyer at Union Bank of India, panel lawyer at India Bulls Home Loans, and advocate at Delhi High Court, panel lawyer at Delhi High Court, at South Delhi Municipal Corporation, and panel lawyer at National Insurance Company Limited, and panel lawyer at RERA, Panchkula. And Rakhi ma'am is the one of the great social activists, and one of the great social personality who always aware the society about their rights, their duties. Now I would like to introduce Rakhi ma'am, and uh, hello, I'm audible. Hello, hello,
Well,
ma'am, I'm audible.
Yes, Manu, you are audible.
Yeah. Please, ma'am, welcome to Rakhi ma'am. Yes, ma'am. Please, it's up to you, ma'am.
Thank you, Manu, for giving my detailed introduction. So, as everyone is well aware that today we are here for foundation course batch 2. What is the foundation course? I want to let you know. Basically, what I have seen, being a first generation lawyer, our seniors were not used to give the basic training in code practice. About law, we are used to learn in the our course of law, whatever it may be, maybe 3-year course or maybe 5-year course. But what we are used to do and what we have to do in the court during our practice, that nobody is used to teach us. So, being a first generation lawyer, I have faced too much problems, and I don't want my upcoming generation in the profession could face these kinds of problems. So we are here to support, to help final year student, fresh law graduates, fresh advocates. Even otherwise, there are so many advocates who are interested and who have joined this particular training. So I would like to warm welcome all of you. So my topic is client dealing. Nobody will tell you how to deal with the client. I'm sharing sharing here the PPT. Actually, not a PPT. It's a basically, you can say, is it visible to you?
Not yet, ma'am.
not yet. Ma'am, the joinees wants to know that can they get the PPTs?
Yes, yes. Whoever is interested can send the request through mail. We will share the PPT. Just give me another minute.
Sure, ma'am.
I think someone has shared his mail ID in the chat box. You are requested not to share the mail ID in the chat box. You will have to send the request on the mail ID through which you have got the link. So PPT is visible to you?
Yes, ma'am.
Yes, ma'am.
Yeah. So some of you are here which has already attended the first session. So this is a repetition to those. Basic are 7 steps to be better advocate for your students. These are the basic steps. If you want to be a good advocate, or you can say better advocate, you must these points in your mind. Be present. What do you mean by be present? Can anybody tell me? What do you mean by be present?
Be
Means that-
present physically and mentally.
Pardon?
Be present both physically and mentally.
Physically, you will have to be, but main contention is that if you are attending a client, if you are in a meeting with the client, you will have to be mentally present there. Until unless you will not be mentally present there, you will lose some contents or some facts to be disclosed by the client. So it's much better be present mentally and listen to your client whatever he is stating to you. Second point is that ask. Why ask? Because we are advocate. हम क्यों पूछेंगे? Client की problem है, client बताएगा. That is a general phenomena. But my concern is that many of the clients are used to be shy, or are used to be, or you are used not to be aware of the proceedings and how to talk with the advocate. They are not used to disclose each and every fact. But being advocates, this is our duty. If you feel your client is missing something to disclose before you raise query, ask, and note down. Main concern is that until unless you are not satisfied with the facts mentioned by or averred by your client to you, you can ask repeatedly, you can query, because you have to put your client's case before the court. And if you are not aware about the complete facts of the case, then how you will proceed in the court? So first contention, be present, ask, and third is listen. You will have to, I'm not stating about listen carefully. Listen. Listen carefully, listen patiently. Okay. Why patiently? Because many times what I have seen, most of the clients are used to repeat their case facts. दो पॉइंट्स बताएंगे, तीसरे पॉइंट पे फिर वापस मेरे हस्बैंड ने मुझे मारा, मेरे हस्बैंड ने मेरे साथ ऐसा किया, like this. So many of the advocates are used to lose their temper by repeating again and again. No, if you will lose the temper, the client will be annoyed, or maybe वो आपसे डर जाए कि my advocate is so much aggressive, how I will deal with her or with him. So listen carefully. Carefully, you will have to note down, you will have to you can say you have to set your client's case fact in your mind, in your case file. Listen patiently. Patience is must. Understand. Next is understand. You will have to understand the problem of your client. If your client is feeling any problem, that is why your client is before you. Your client wants your support to present his or her case in the court. And until unless you will not understand your client's problem, you will not be able to present your case before the court. Basic thing, you will have to satisfy yourself with the case facts of your client. You will not be understand, then how you will make understand to the court, how you will put your case facts before the court, how you will get the relief from the court. Next, speak up. Whenever you feel your client is talking like beyond your case, beyond his or her case, then you can mention, see, this is not your case fact, so Keep yourself limited up to your case. Don't go beyond that. That's it. Take action. Can anybody tell me what is take action? Please participate in the training session. Take action, please. Can anybody tell me?
Hello, all. Please participate and answer to the ma'am. What's the point in joining the session if you are not asking any queries or not? You don't have any questions. At least give it a guess.
Take action means like we need to ask a cross question with the client for their to understand clearly regarding the case, I guess.
Okay, nice efforts. But take action means, supposingly, if your client says, I have come to you for bail, he is in prison, he is behind the bar, or his family member is behind the bar, and he is saying कि मुझे तो कल ही bail file करना है. Don't ignore that. Note down the case facts, take the appropriate documents, and take immediate action. Means take action means, if he says कि मुझे कल ही bail application file करना है, तो you will have to take action to file bail application on the next day. Okay.
Yes.
Always encourage. Many of the clients are used to come after visiting much more lawyers, much more advocates. They are used to come for another opinion. He is used to say, ma'am, मुझे तो उसने ये बोला था कि इस केस में कुछ नहीं होने वाला. You are not going to get any kind of relief. Court will scold you. Court will dismiss your case. Blah blah whatever. But this is the point you have not done. You have to encourage your client. You have to say, let us see, we can try. If your client's case fact suggests that the case will not having so much sanctity, we can try now. We can try at least. So encourage your clients. If we will discourage our clients, then they will lose the hope. Because my understanding is that if there is a problem, there is a specific law to resolve that problem. Okay.
Yes.
So next is confidential. क्या बनना है? I have said confidential. What do you mean by confidentiality?
Means not disclose any confidential data of the client or confidential information of the client. What she or he is sharing with us, that should be in no matter to share with other one.
Yes. Good efforts. Main point is that in many of the cases, client is having presumption that the advocates are used to share the details of the case to the other party advocate or with any other one. If they show their intention that our case fact should not be shared with anyone, so you have to assure them your case facts will be confidential, will not be disclosed to anyone. Okay. main thing is note down. Many times what I have observed in my practical life, generally clients are used to check what kind of advocate it is or she is, whether she is serious to our case or not. And when we are discussing the case with our client, we must note down his case facts. The reason behind that, if we don't note down, then first impression upon the client will be negative. He can think that his advocate is just ignoring me, or पता नहीं मेरे केस फैक्ट पूरे से इनको याद रहेंगे या नहीं. And moreover, if you are seriously taking that client, then it will be helpful to prepare your case file if you are noting down the case facts. Till the final disposal of the case, those particular notes which you had noted down not only be noted in your booklet or your paper, but also in your brain. So you will have to note down the case facts. Then the main thing is that don't be available every time. Don't be available every time. Can anybody explain about don't be available every time?
If we show them that we are available every time, they will not have much confidence in us.
Yes. Any other way?
They would ask unnecessary questions time to time or repeatedly ask the same question when we are available for answering the same thing again and again. And this would impact our presence, that they would also think that the lawyer is free, he or she do not have very much cases, or he is not engaged in all the cases. That's the reason behind he is available all the time.
Exactly.
And,
that is the main contention.
Okay.
Yes, continue, please.
And if we are not available all the time, then we would also get some time for research and other important things, and we can focus importantly over the client case accordingly.
Yes, yes. May I know your good name, please?
Abhishek.
Yes, very nice, Abhishek.
Thank you, ma'am.
मेरा काम तो आपने ही कर दिया, अभिषेक. So next is no long discussion. If your client has called you, and many times what I have felt, what I have noticed, if I have attended the call and ma'am, just 2 minutes, just 2 minutes, just 2 minutes. By this way, they are used to take 30 minutes, 40 minutes, 50 minutes. And by this way, they are not doing anything. Just repetition of questions and wasting my time. If you will be available every time over phone to the client, he will never visit to you. He will disturb you over call again and again. He will not see it is a court time. He will not see this is a family time. He will call you. So try to be less available over call to the client. I'm not denying don't be available over call. I'm stating less available wherever is required, just for 2-3 minutes. If the client is lingering on the process or lingering on the wordings or case facts, You can say, okay, sir, right now we have to go somewhere, or we have to go, I have to go to the court, or I'm busy somewhere. You can come to my office, you can come to my chamber, whatever you want to say. Call him physically and have meet. By this way, what you will get? What you will get by this way?
A client will also regard your time and that effort. He will and nowadays one more thing is also going on, that on call there is an option of recording. So might be we used to say or narrate anything in a different context, and client used to understand in a different context, and he used to record the same thing, and later on he will give the reference of the same thing. Ki, last time you said like this, and this time you are saying like this. The way
Yes,
he will treat, that would also be not beneficial for us.
yes. This is one part. Second part is that over call, he will discuss with you without any remuneration. He will waste your time, and discussion will be you, and he will take suggestion and will go to another lawyer. Moreover, if you will meet him personally, you can charge consultancy charges as well, and he will have to pay. Got it?
Yes, ma'am.
Last but not the least, sometimes we are used to discuss the case with, if we are in association, so all advocates in association are used to sit along with the client. Sometimes clients say कि सर मैं इन सबके साथ कंफर्टेबल नहीं हूँ, मुझे अकेले में बात करनी है. तो डोंट से कि नहीं नहीं जो भी बात करनी है इनके सामने करो. नो, client will lose faith in you because he has come to you with your name, by listening your name, that so and so Abhishek, Priyanka is a very good lawyer, they are used to give attention to the clients. So don't do that behavior. And okay, इतना आप लोगों में, आपके एसोसिएट्स में इतना कॉमन अंडरस्टैंडिंग आपस में होना चाहिए. इफ द क्लाइंट इज सेइंग ओके दैट इज नॉट द इशू, हम लोग अलग से बात कर लेते हैं. Main thing is that client should be comfortable with the advocate. So if the client says I have to discuss in person with you, so you can. Okay.
Yes, ma'am.
So this was client dealing. If there is any query, you can ask. If there is any query, you can ask.
Ma'am, just wanted to know that how we should fix the rate. Like in few cases, I used to see that they advocate used to charge a one fixed amount, like 20,000, 30,000 to take up the case, and after that for per hearing, they used to charge that. Like either online hearing or offline hearing, they used to charge accordingly. That so how we should fix the charges?
See, it depends upon your own. Okay. If you say that I will charge 20,000 from you for your case, then you can, but you will have to make up your mind. You will have to fix the fee structure. But my contention is that you will have to see the face of the client. If a client who is hand to mouth, only earning hand in his family or her family, and I'm saying कि नहीं नहीं मुझे तो 1 लाख चाहिए ही चाहिए, then client will not be stable to you.
ये one time fees होता है किस चीज? Sorry.
But with the passage of time, when you will settle your practice, then you can make a trend like Advocate Rakhi Buddhi Raja is charging this fee. So before coming to you, any client who is well aware, like Mr. Jetmalani the, Hari Salve ji hain, they are having a fixed fee structure, and anyone who is interested to get them higher or get him higher, they will have to settle in their mind that we have to arrange such such a big amount or such a amount that we have to give them as a fee. If you want to settle this thing, you will have to settle, and it will take little bit time, but you can settle it.
इन स्टार्टिंग हाउ में वी जस्टिफाई दैट थिंग, अगर हम 20,000 रुपए चार्ज कर रहे हैं तो वो 20,000 हम किस चीज के लिए ले रहे हैं फर्स्ट टाइम?
किस
वो
चीज
क्यों
के लिए ले रहे हैं? मतलब इफ यू आर contesting a
फर्स्ट टाइम?
case, you are contesting a case in the court, you are charging the legal fee, drafting है, court presentation है, attestation है, photocopy, everything is there.
फॉर दैट थिंग वी यूज टू चार्ज एक्स्ट्रा, लाइक जो एडवोकेट्स होते हैं वो अलग से चार्ज करते हैं कि अगर हमें कुछ प्रिंट आउट लेना है या फिर जेरोक्स करवाना है या उसके लिए अलग से चार्ज होगा
Some
वन टाइम?
advocates, some advocates are used to charge extra, additional, not extra, additional you can say.
यस मैम.
Some advocates are used to charge additional, and some advocates are used to charge one time, but they are used to declare that everything will be there in whatever maybe drafting charges, or like me, I'm used to charge my fee, and I'm used to say this is your drafting charges, and everything will be there in, but you will have to clear cut before you apply.
Sorry to interrupt, ma'am. I would like to request everyone to just unmute and ask the questions instead of typing in the chat box. It gets difficult to read the chat box while ma'am is explaining. So it's better to unmute and ask.
Anybody else? Anybody else, please?
Ma'am, there are 2-3 questions raised in a chat box by Mr. Saurav Pathi and Mr. Neeraj.
Just a minute. Prepare petition, Mr. Ravinder Singhal, what do you want to say? Prepare petition, Mr. Ravinder Singhal,
Ma'am, he
are you
said
available?
between where you asked to take action, what do you mean by to take action? At that
Okay.
point, he texted for that preparation.
Okay.
There are last 2 questions where Mr. Neeraj is asking, while you were saying that not to entertain clients much, though you should always give time to them whenever they need it. So he was asking that, is it that mean basically setting up boundaries with your clients? Is that right or wrong?
No, I'm not saying that we should not give the time whenever they require. I'm not saying like that. Don't misinterpret it. You are misinterpreting it. My concern was that don't be available every time over call. Okay.
Yes. And
that what types of charges advocate can take from?
Mr. Joginder has asked what type of charges advocates can take from clients.
That depends totally upon you. You can take legal charges, your legal fee, drafting charges, or like photocopy and all. If you want to get the consolidated fee, you can take consolidated fee.
And there is one question asked by Mr. Saurav, that we have heard that advocate Harish Salve gets the fact of the case in one meet with the client. So how can we frame the question so we can get the information effectively?
That is why I stated to you, if you are listening to your client carefully, and as per the case facts, you are not getting the proper case facts, the case facts which your client is stating to you, and you are not getting the case facts as per the case for which relief he is wanted, you will have to raise the question as per the case facts. Supposingly, someone has come to you for divorce. One person has come to you for seeking divorce from his wife, and he is repeatedly saying about their marriage, ye hua wo hua, but what is the main reason why he wants to be separated from his wife? If he is not telling, then you will have to raise the query, you will have to ask the question, and that is not mandatory. I'm not saying about Mr. Harish sir that he has suggested wrong or what. No, as a senior lawyer, he suggested good that in 1 minute you can take case facts from your client, but sometimes case facts are too long. Supposingly, like one party came to me and उनकी मैरिज को करीब करीब 22 साल हो गए थे, तो 22 साल के केस फैक्ट्स को एक टाइम पे नोट करना, आई डोंट थिंक सो दैट विल बी एप्रोप्रिएट. Some major points can be missed out. You can call them for once or twice. In 2 meetings, you can wind up all the case facts. Being new advocates, being fresh advocates, you can take time, not an issue. And basically practice makes a man perfect. Till the time when you will reach at the stage of Mr. Harish Salve, hopefully you will get the brief within one meeting.
Thank you so much, ma'am. That was all the questions from the chat box.
Yeah, so next is file management. So can anybody explain about the file management? What is file management?
Maintaining all the client's data, like what we are getting from the client end, what we prepared, all the things, like in the law, there are lots of CRM which we use to maintain the things and client data on a cloud basis. So we can retrieve the data anywhere where we would require to do it. So like that.
Anybody else? See, if we say about the soft copies of the files, then we can save it in Google Drive or cloud file, etc. But as we are well aware, in many small cities, small areas of our country, India, basically these things, people are not aware about the IT system and all. So as of now, they are used to prepare the case files physically. This which is our old system, still working, and I'm also working on this system because I'm not satisfied with the soft copies and all. Until unless file doesn't come to my hand, then I feel that I'm helpless. I need file. So how you will prepare or manage the file? First of all, you will have to take any legal file or envelope or file cover. You can use that. Documents be kept pleading wise or date wise, and the same should be punched and tagged properly. Like you are a plaintiff or petitioner, you have to keep first your petition, then you got written statement from the court. You can uh, on second number, you can put the written statement, then rejoinder, and then thereafter evidence and miscellaneous documents and arguments, copy of written arguments. Like this way, you can manage it. documents in the file be flagged or bookmarked. The important documents which you think that will be helpful to argue or to show in the court, those should be flagged properly or bookmarked, so that when you are discussing about those documents in the court, you can easily trace them in your file and show to the court. Day-to-day proceedings. Day-to-day proceedings should be notified in file. My way of work is that on daily basis, when I'm used to go to court, whatever has been done in the court, whoever be presented, whether myself presented, whether my associate has presented, we are used to mention on a paper, Mr. So and so presented before the court. These and these proceedings were done. Now this case is put up for so and so proceeding. Next date of hearing, so and so. We are used to mention the next date of hearing on the face of the file, not only on the face of the file, but also on the particular page. And tag that particular page just on the petition of your file. Just first page of the petition. Thereafter petition will start. You can say this is a kind of order sheet. Okay. Next is receiving of PF. Are you aware about the PF, process fee form? Talbana. Is anyone aware about that? I think there are so many practicing lawyers.
When we court call someone like to present in the court, then Talbana used to issue that.
Yes. So I'm telling about the receiving. When we are used to submit the Talbana form, PF form in the court to concerned Ahmed or court staff, he is used to give us the receiving. About that particular receiving I'm talking, what we are used to do, we are used to paste that particular receiving on the plain paper and put that sheet in the file, so that on the next date of hearing, if the party has not come, we can show to the court that, see, this is the receiving, we had done the PF form, we had done with the Talbana. Why the party has not come? We are not aware. We had done our job. Sometimes if we are not used to save or keep this particular receipt, or we have missed that particular receipt, so we have no proof that we had done the Talbana or we had done the PF. So we have to convince the court. If the court asks, आपने PF किया था, आपने तलवाना किया था? Yes, I have the receiving. That's it. Copies of day-to-day orders and proceedings, along with the certified copies of important orders, be kept in your case file. Supposingly, in any case, you have got any interim order of interlocutory application or any kind of important order you have got, either in your favor or against you, get the certified copy and keep it in your file. As far as day-to-day proceedings are concerned, we can't take day-to-day proceedings, but we can download from websites of the court. Most of the courts are used to upload the daily orders in the court website. So you can download and you can tie it with your file. So that is file management. Is there any query about file management?
No, ma'am.
Okay. So next part is court presentation. That is very much important part. Court presentation. Please tell me anybody who can explain or who can brief how to present yourself in the court. I'm not stating about case, I'm stating about yourself. how you will present yourself in the court. Being an advocate, how you will present yourself in the court. There are so many advocates in the training session. Please say no, yes, no, at least.
Confident, being
Ma'am.
confident,
Pardon?
being confident,
Okay.
You must study your case file and the case before appearing in court in front of judge.
I'm unable to see who is on the screen.
Ma'am. Advocate Priyanka.
Priyanka, besides you, besides Priyanka, who and anyone who can suggest?
yeah, ma'am, I just said being confident and keeping all the files ready. Obviously, the dress code should be maintained.
First of all, I would like to, if everyone open your cameras, please. Everyone open your cameras, please. I'm looking at, there are 33 persons who are attending the meeting, and little bit persons are there who are on the camera. Please participate actively. एंड जरूरी नहीं है कि मैं यहाँ ट्रेनिंग सेशन ले रही हूँ, मुझे सब कुछ आता है, हो सकता है मैं आपसे भी कुछ सीख कर जाऊँ. सो प्लीज पार्टिसिपेट एक्टिवली. Not an issue if you don't want to be on camera, not an issue, but participate actively at least. It's my humble request. Not an issue, Nagesh sir, not an issue. My concern is everyone should participate actively. So next is code presentation. The basic contention or basic contents for an advocate to present himself or herself or his or her case. There are two things. First time, if you are appearing the court, you are presenting yourself along with your case. With the passage of time, you will be habitual. Then only you will have to present your case. Otherwise, because we are here for fresh advocates, for law final year students, so it is mandatory to tell you whenever you will start your practice, whenever you will starting going to the court, on each and every day. Not only you will have to present your case, you will have to present yourself as well. So, before appearing to the honorable court, you will have to be confident. Confidence is must. If you are not confident, then you will not able to appear in the court, or you can say आप घबरा जाओगे. So how to be confident? First, dress up properly. Dress up properly as per dressing sense of an advocate, which already have been explained to you by Advocate Priyanka Saneja. Second thing is that knowledge of your case facts. If you are well aware about your case facts, you will be too much confident. You will never lose your confidence. Two basic things: your dress up, your case facts. Next is, whatever you are presenting your case, you must aware about the law related to your case. Supposingly, if you are presenting your case related to Domestic Violence Act, you are arguing before the court or you are mentioning your case facts. Suddenly, court has asked, okay, you are asking for maintenance for your client. So where is the provision? What is the provision? If you are well aware about the provision, you can mention. And if you are not aware about the law, you will be silent. If you will be silent, it will create a negative image before the judge. And first impression is the last impression. Last, you must have to aware about the latest case law with respect to your case. I'm giving here an example. Supposingly in DV, I'm taking the example of DV only. In DV, you are claiming maintenance and you are not mentioning that your client, means complainant, is unable to maintain herself by giving the genuine reason why she is unable to maintain herself. However, she is qualified, she is having experience, but right now, why she is not able to work, or why she is not unable, why she is not able to earn to maintain herself, then court will not give any heed to your prayer clause. If you are any criminal cases pending, you are filing a bail application along with the proceedings, until unless you will not press the court on your bail application, the court will not entertain properly. Case law is must, case knowledge is must, dress up in proper senses must, case fact should be on your fingertips. Okay. Second point is that being an advocate, you will have to humble while mentioning your case before the court. It is my own personal experience. In court, many advocates, most of the advocates you can say, are used to be aggressive while arguing the matter. That is not good. If you are getting aggressive, what the court is used to do? Court started working on another case. Courts is used to start giving dictation to his staff, but with regard to particular or any other case, to write down the order. Okay, I'm listening. Keep it up, keep it up. So if you are humble before the court will listen with patience. If you will be aggressive, court will ignore you. Maintain the decorum of the court. How you will maintain the decorum of the court? First of all, keep your phone on silence. If we are sitting before the court, we are chit-chatting on WhatsApp, Messenger, or any other app. That is not a good thing. Someone is calling you, you are in court. What is your duty? If your case is not going on and you are still waiting for your case, you can go out of the courtroom and take your call. Many of the lawyers, what I used to do, like court is listening to the case, and behind the chairs you are getting your head down and listening the phone like this. So this is also not a good thing. Many times, I'm sorry to say, I have noticed in the court, fresh lawyers and new generation lawyers are used to stand in the court, even before the court, like this way or like this way, putting their hands in the pocket. So that is not as per the decorum of the court. Maintain the dignity. Many times, many of the lawyers are used to create hypothetical situation in the court by mentioning irrelevant things instead of mentioning their case facts. In one of my case, it was 138, which is still pending in the court. I had filed an application for 311, recalling of witness. The complainant side counsel opposed in the court verbally, not in written, verbally he opposed, and he started shouting. Uh, he started shouting and stating against me before the court. She is not considering the order of the court, blah blah. I was listening patiently. Just I said one thing. Your Lordship, if I'm not paying any heed the order of the court, then why I have filed the application of 311? I'm listening to the order of the court. I'm listening to the counsel of the complainant, who is having anything before the court. Even court is noticing. Court notice this thing. Court notice he is stating irrelevant things. Court even notice he is arguing on irrelevant things, not on the facts. I got relief from the court because of his behavior. Court allowed my application. What I noticed at that time, due to the behavior of the said lawyer, if I also got adamant and I started shouting upon him, or I could have replying to his irrelevant things, perhaps court must have dismissed my application. So don't argue irrelevantly in the court. Go only on merits. Next is, many times we have seen new lawyers are used to say, this is totally different. Whatever we have seen in the movies and series, this is totally different. Yes, real life is totally different from real life. Don't search in real life practice whatever you are looking or whatever you have seen in the real life. Don't go beyond your limitation as an advocate to win the case. Why I'm saying so? Don't go beyond your limitation as an advocate to win the case. Many times, not many times, I have seen many lawyers. I have seen, personally, I have seen, I don't want to disclose their name. They are used to work as detective as well for their client. So is that ethical? We are lawyers, not the detectives. We are the officers of the court. Sometimes the lawyers are used to do such kind of activities, such kind of things. ठीक है, मुझे केस जीतना है, मुझे अपने क्लाइंट का केस जीतना है, कुछ भी करना पड़े. नो, हमें कुछ भी नहीं करना है. हमें ऑन मेरिट्स, हमें केस के फैक्ट्स पर लड़ना है. Our foundations, our limitations are up to litigation. Being a litigation lawyer, we are bounded up to court, whether it may be district court, whether it may be high court, whether it may be Supreme Court or any other tribunal or whatever. We can't go to being detective or any other thing until unless the court doesn't order to us like a local commissioner or receiver. Listen carefully whatever the court is offering during your case proceedings or arguments. Again, in one of my case, I was arguing the matter. Court was listening to me and arguments were going on very well. Suddenly, the opposite counsel started uttering this way or that way. The court got annoyed. The court starting passing the order. He was not listening. When I listened, the court is ordering in my favor. I kept mum. The opposite counsel got surprised. Why she got silent? She was arguing the matter. Why she got silent? He asked me reluctantly, "Ma'am, continue na? Why you got silent? Continue. भूल गए क्या?" Even judge passed a smile. I also passed a smile. I said, "Mr. Counsel, the Honorable Court has passed the order in my favor." These are the texts of my practice. He had not listened to the words of the judge, what the judge has averred. He was not aware कि जज साहब ने order भी pass कर दिया, because he was reluctant. He was aggressively opposing my arguments. He didn't give any heed to the court order. These things can create negative impression before the court. Next is, if you find that the court is commending to your case or any point of your case, stop immediately arguing. Otherwise, same case can cause negative effect to your case. This is almost similar to the last example which I had given to you. If the court is commending with regard to your case and you are continuously arguing, the court will stop. Court will not pass any order in your favor, or if it will pass, court can scold you in the court. So it's better to keep in mind all these things. Okay, one more thing, one more important thing. Like, if court is scolding to opposite counsel on any point, don't accelerate. Many times we advocates are used to when court is scolding to the other advocates, आया ना मजा, court ने तुम्हें डांट दिया, आया ना मजा. So don't do like that, because court is noticing everything. Today, whatever is happening with your opposite counsel, tomorrow the same can happen with you. And even judge can say, क्यों मैडम उस दिन तो आप बड़ा खुश हो रहे थे, आज आपकी बारी आई तो क्या हो गया? Okay, so don't accelerate. Last but not the least, when your opposite counsel is arguing, this is general phenomena which what I am telling. While arguing by the opposite counsel, don't interrupt him. Notice all the points, whatever he is arguing, notice all the points. When you will get your turn, reply accordingly. Don't leave any point without reply, otherwise it will be considered as admitted. Don't be silent, because as per law, silence means yes. If on any point you are silent, You are not uttering even a single word in opposition. मान लो आपने admit कर लिया, because silence means yes. So these were the points of code presentation. If there is any query, you can ask.
Ma'am, one more point I would like to add, that he should not use any slang like yeah sort of things in the code.
Yes, yes. Yes, one more thing I want to tell you. If anyone want to add on whatever I'm telling you, you are most welcome. Don't think I'm teaching you. Think like we are discussing. Because I don't want to say I'm a senior advocate or you are junior advocate. We all are advocates. There is no senior, no junior. We all are advocates. So if anyone can add on, you are most welcome.
Ma'am, I have one query. Like while presenting our case, if I'm not comfortable to speak in English at that moment, or I am not getting any particular word for the same thing, then can I continue the same thing in Hindi language?
Yes,
Uh,
please.
or it would be
In
not.
district court, there is no issue. In High Court, Supreme Court, nowadays in Supreme Court, it is also admitted. You can request to the Honorable Court and you can continue.
As I saw in the YouTube some case that one of honorable judge, High Court judge in Patna, didn't heard the advocate that thing, दलील उनकी सुनी नहीं उन्होंने और रिजेक्ट कर दिया कि हिंदी में नहीं अलाउड है, वो इंग्लिश में ही होनी चाहिए सॉर्ट ऑफ थिंग्स.
अभी आपने शायद सुप्रीम कोर्ट की लास्ट कुछ डायरेक्शंस आई थी, इवन उनके ऑर्डर्स भी अलग अलग लैंग्वेजेस में तैयार हो रहे हैं. And when Supreme Court is allowing the things, then High Court must do for the same. Any other thing? Anything else? Please reply, at least reply is expected. Okay, if you don't want to say any words, you can give me the thumb impressions. So,
we got the maximum information required, but
Pardon?
questions will not be coming just now. So it will take some next sessions or something.
okay. Even otherwise, if you are having any question in your mind, you can send your queries to the mail ID through which you have got the link.
Sure.
Okay. So next session will be of diary management, and that will be taken up by Mr. Advocate Bhanu Kalsan. I would like to call upon Mr. Bhanu Kalsan. Bhanu, please.
Thank you very much, ma'am, for providing this opportunity to me. Firstly, I'm just asking to all of you participants that what's the main use and what's the main particular diary in an advocate's life? Is there anyone who is interested to tell me about the diary in an advocate's life?
Yeah, in diary, any advocate can be able to note it down the main case fact.
Yeah. Good.
So it will be very helpful for him or her when while studying the case.
Yes, you're right. Good. Okay. Okay. I'll tell you further. The advocate's diary mainly focus on the case information which is required to you for the further proceedings, like previous date, case number, name of the court,
Bhanu, just hold
and
on.
the
Bhanu, just hold on. Your voice is not clear.
hello, ma'am. Now it's clear. Hello.
Everyone, the voice is clear.
No,
Yeah,
ma'am.
I'm
No,
audible.
ma'am.
Not very
Ma'am,
clear.
you are not properly audible.
Just, wait a minute, ma'am.
Bhanu, if you say,
Hello.
can I continue?
Ma'am, if I'm not properly audible, you can continue. If I'm audible, then I can.
Tell me, everyone, if Mr. Bhanu is audible to you. If
No,
he is,
No, ma'am.
pardon?
No,
He's-
ma'am. Not very much clear.
I think there's something audio issue, ma'am. You can continue with the diary management, ma'am. I'm not properly audible to the all.
Try once. If it will not be properly working, then I'll continue. Try once.
Hello, ma'am. Please continue. I'm not properly audible to all of the participants.
Okay. So, what is diary management? What is diary basically? Diary is I will say it is an instrument for an advocate. Diary is an instrument for an advocate wherein an advocate can write down the detail of the case and keep it as record. So this is a page of diary wherein we are used to mention here in previous date. What was the last date of hearing? You can mention there. What is the case number? You have to mention there in name of the court, means name of the judge with area of the court. Like here in Delhi, if we are discussing about District Court Rohini, District Court Tisasari, Dwarka District Court, High Court of Delhi, Supreme Court, along with the name of judge, you will have to mention here the name of the court as well. Here you will have to mention the name of the parties, A versus B, ABC versus DEF, like that. Here in the case status, you will have to mention on which state, or sorry, on which stage your case is going on. What is the stage wherein you will have to appear before the court on the next date of hearing, or what kind of proceedings you have to accomplish before proceeding to the next date of hearing. On last column, you will have to mention next date. What is the next date of hearing which has been given by the court, and you will have to appear along with your case file in the court. So what is the use of diary? This is the basic use. Generally, as per today, many of the advocates are used to say, this thing we can do in a phone, Google Calendar. What is the need of diary? Again, this is the old system and still continue. I have Google Calendar. We are used to update on daily basis, but unless I'll not catch the diary in my hands, ऐसा लगता है कि हाथ में कुछ है ही नहीं. वकील के हाथ में जब तक उसकी फाइल, उसकी डायरी नहीं होगी, कंफर्टेबल फील नहीं करे. These are our instruments. These are our instruments. Engineer के हाथ में like screwdriver and all these things. Doctor के हाथ में medicine, stethoscope, like this. What will be in the hands of advocates? Pen, column, diary, file. At initial stage, for fresh advocates, you can memorize the cases because number are very less. And when you will reach at the stage of, or at a high level advocate, you will have to write down the diary. But if you will start at that stage, आपको आदत नहीं होगा तो आप नहीं नोट डाउन करोगे. So to create a habit, you will have to prepare a diary as well. So that was the diary management. If there is any query, you can ask.
No
Is
questions.
there query? Is there any query?
No, ma'am.
Okay. So let us move to very important aspect. However, everything is important in the foundation course, but this is the most important thing, that is called performance, which as per my knowledge, every lawyer should know how to fill these kinds of documents. So first performa I'm showing you is a wakalatnama. This document is a wakalatnama. What is wakalatnama? Can anybody explain?
What is the name of advocate?
Pardon?
When we choose any new advocate, then we used to get it signed, the wakalatnama from the client.
Yes, but
So
what do you mean by wakalatnama? Why
it's a basically
wakalatnama?
it's a consent from the client end that ki, as an advocate we are fighting behalf on her or him in the
Yes,
in the court.
yes, yes, yes. Wakalatnama is a document through which we get the authority to present our client's case before the court. That is called wakalatnama. So this wakalatnama is used to be used in Delhi. Every state in India is having its own wakalatnama. Somewhere it may be of in Hindi language, some may be in some courts the same wakalatnama is used to be used. Here we are used to paste court fees, but in some courts like Haryana, the bar itself provide us the wakalatnama wherein they self are used to affix the court fees or welfare tickets and etc. So wakalatnama is mandatory before presenting the case on behalf of our client. And this document we will have to sign, and we will get the sign of the client and submit it before the court where the case is pending on behalf of our client or where we are going to fight it. This is wakalatnama. So in wakalatnama, here we can say in the court of, we have to mention here the name of court. What is case number? Here we have mentioned suit or appeal. You can mention here FIR number, under section, police station, whatever. INRI means the name of case. Here the name of first party, here the name of second party. And here you will have to mention the name of that party to whom you are representing in the court. Here you will have to mention the above name, whether he is the petitioner, plaintiff, means first party. Then you will have to mention here plaintiff, petitioner, applicant, complainant, whatever is applicable. And if you are presenting the second party, then here you can mention defendant, respondent, accused person, etc. Below given, if there is single client, you can get it signed here. If there are two clients, one wakalatnama is basically you can use for two clients in same case. Here you can put your signature. Here you can mention your details on vacant place, or you can mention put your stamp of advocate, so that your enrollment number, your mail ID, your enrollment number, phone number, mail ID, your office address or chamber address should be notified here along with your name. Next will be memo of appearance. Memorandum of appearance. Why this memorandum of appearance? Can anybody tell? Why memorandum of appearance? Okay, let me tell you. Memorandum of appearance is a kind of wakalatnama wherein we don't have the signature of our client. And that is only for a single date. Supposingly, your client is out of his place. He got the summons or he got the call from the court on the next date or on the very next day. His case is listed in the court. He just called you, sir, my case is listed and you will have to appear. You don't have the wakalatnama of your client. In that case, what you will do? But condition is that you will have to appear so that adverse order should not be passed against your client. Take a memorandum of appearance, fill the detail of the case, sign it, and submit it before the court. Court will get assurance from you that on the next date of hearing, you will file the wakalatnama on behalf of your client. That is called memorandum of appearance.
Ma'am, one question here.
Yes.
Is there any limit, like how many wakalatnamas in one case one can file? Like sometimes client have their open multiple advocates, right? So
see, as far as wakalatnama is concerned, as per my knowledge, it is limited up to 3 years, and as per rules, fresh wakalatnama for the same counsel also be filed after completion of 3 years, but generally it is not used to be done. However, in district court, if your client wants to change the lawyer, he can change and present the fresh wakalatnama of his new lawyer. The court will not object. But in the High Court and Supreme Court, you will have to get the NOC from your previous counsel to change the lawyer. Until unless the previous counsel will not issue NOC, the fresh wakalatnama for new counsel, you can't submit before the court. Because this is general presumption. If you have not got the NOC from the previous counsel, that means you had not given the litigation charges to your advocate. That is why your client is not issuing the NOC. And this is the sole reason most of the times advocates are not used to issue the NOC, only because they had not received their complete fee as per discussion or as decided by the party and advocate.
okay.
Any
Thank
other
you.
query?
I have one question. Hello.
Yes, yes.
Instead of submitting a new wakalatnama, can we file the joint wakalatnama when there are sometimes the old advocate is not giving the NOC?
You can file the joint wakalatnama, but there should be a
Or additional wakal. No, it's not a joint wakalatnama, it's an additional wakalatnama.
Additional wakalatnama can be filed, but your what will be your motive to get it filed as additional wakalatnama?
Because sometimes what is happening now, the previous advocate is not giving the NOC. He will take the time to give the NOC 2 months, 3 months, 5 months.
You can file the additional wakalatnama, but my concern is that if today the thing is happening with the previous counsel, the same thing can happen in future with you.
Okay.
That is the reason I recommend for NOC. And if you are filing the additional wakalatnama, court can take it. But the problem will raise and you will, both of the lawyers will fight against it. So for a client, 5 lawyer should file.
Okay. Yeah, thank you.
Next is process fee form. As I have already told about PF form, process fee form, Talbana, this is the process fee form. When the court pass the order to issue summons to the opposite party or respondent defendant by filing process fee form. So here is the process fee form. How to fill it? I'm telling you. We have to mention the name of the court wherein the case is pending, case number, suit number, name of the parties, ABC versus CED, previous date of hearing, you will have to mention here, next date of hearing, you will have to mention here. Now, date of filing. Date of filing means on which date you are filing this PF form. Mind it, whenever the court is used to pass the order of someone by filing PFRC, there is a limitation. Either the court is used to issue order or pass order of 3 days from the date of hearing or 7 days, maximum by 15 days. Okay. So date of filing, filed by whom? We have not to mention here the name. We have to mention plaintiff, petitioner, whatever is applicable here. Purpose of filing. Notice to respondent, defendant, accused, whatever is applicable. This is most important. Number. How many defendants, respondents are there? 1, 2, 3, you will have to mention here. Amount of process fee. Now, amount of process fee depends upon the number of the respondents or defendants. In Delhi, it is 1 rupee and 15 paisa per accused or per respondent. So we are used to consider it 2 rupees. If the respondent is 1, then you will have to multiply 2 by 1 and you will have to affix court fee here of rupees 2 as per number of the respondent to be summoned. If respondents are 2, 3, 4, you will have to multiply all the respondents with 2. Supposingly they are 5, then you will have to mention a rupees 10 and rupees 10 court fee you will have to affix there. Again, we will have to fill all the details, same details which is mentioned above in the particular form, same detail we have to mention. And this is the portion which I stated to you earlier, PF receiving. The concerned staff of the court will take the PF form, cut this piece and put his signature over here and will hand over this receipt to you. That means he had got the PF form from you in this case, and this is the proof of that particular receiving. This receiving you will have to paste on a white paper and keep it as record in your case file. Got it?
Yes.
Next is address form. What is address form? When we are used to prepare a case, so it is mandatory to keep this address form at the time of filing along with your case file. As usual, name of the court, case, what is the case, ABC versus DEF, what is the suit. If it is case, then you will have to mention there on the before the case. If it is suit, you will have to mention here date of hearing, not fixed or pending. Here we have to mention the detail of the parties. Okay. And we have to put this document along with our file and submit it before the court. Next is checklist. What is checklist? Can you just hold? Sorry for interruption. Checklist. When we are used to file a case, again, we are used to attach the checklist. This is a normal checklist. There are two kinds of checklist. One is normal checklist and one is checklist of 138. So I'm showing here you normal checklist, which is generally used in all kind of cases instead of 138 NIA. Valuation of suit jurisdiction. Here we have to mention the valuation of the suit. It can be territorial. You can mention here the police station of the concerned area where the cause of action has arisen. Name and address of the advocate. Here you will have to give the detail, give your detail, nature of suit. So here you will have to mention the provision and mention the name of the act or code. Age of parties. You will have to mention here age of plaintiff, here age of defendant. Caveat. Whether any caveat is pending against plaintiff or on behalf of plaintiff. If yes, then you will have to mention yes and you have to give the detail. If no, then mention not applicable. Whether any earmark code means whether any attached case is pending in any other code, then you will have to mention here. Like if there is a suit which is pending in a court of law, and on in the same case in an interlocutory application, or you are filing any interlocutory application in the same court, then we are filing this checklist. So we have to mention the detail of that particular court where the main case is pending. Getting my point? अभिषेक जी नहीं समझ में आया? अभिषेक जी, I think you are on mute.
यस मैम, आ गया समझ में। वो मैं ऐसे ऐसे कर रहा था तो सॉरी।
Okay, you are nodding. I thought you are not getting.
Sorry.
Okay, thank you. So court fee. Court fee, if there is a single case, means single relief, then you can mention like this way, how much amount you had paid, or the particular amount for which the court fees has been affixed. Otherwise, if we go through the DB Act, so relief sought like section 12, section 17, 18, 19, 20, 21, 22, you can mention here, and as whole the total fee you can write down here. Connected cases, if any, name of the court where pending. So दोनों पार्टी से related अगर कोई connected case है, beside this you will have to mention therein in which court it is pending. You will have to mention what is the next date of hearing. Again, you will have to mention here in the column. That's it. Now this is the checklist for 138. This is the checklist for 138. I think it is visible to all of you. I have not asked.
Yes, ma'am, it's visible.
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Okay. So detail of the case, whether 138 NI Act, complaint case, etc. So we have to give the detail herein. Total checks amounts only in 138 cases. How much checks got bounced, you will have to mention here. And total amount, what is the total amount? You will have to mention here. Area of bounce check. Okay, one more thing I want to tell you. However, that is not the part of this training course that will be concluded in 138 when I will take it. But as of now, because this is a column number 2, total check or checks amount only in 138 cases, तो क्वेरी रेज होती है कि अच्छा क्या एक से ज्यादा चेक में भी एक केस में चेक फाइल किए जा सकते हैं? यस, बट अप टू limit is up to 4 checks. In one case, you can file or you can submit detail of 4 checks. In one of my case, I'm telling you, same parties were there, not were there, are there, those cases are still pending. There were 8 checks. There were 8 checks which got bounced, and that particular party had to file 2 different cases on same cause of action. But because checks were 8, only that purpose he had to file 2 cases, 4 checks in one case and remaining 4 checks in another case. So we can use 4 checks in one complaint. If you are taking 5 checks in one case, then your case will not be admitted. Next is area of bounce of check. Area of bounce of check means in which area the check was bounced. Means your bank, you had presented your check in your bank and that got bounced. Like you are residing in I'll take the example of Delhi. If you are residing in Dwarka and check was issued from Pitampura, so area of bounce check will be Dwarka. Whatever the sector you can mention therein. So you will have to mention the area where the check got bounced. This will decide the jurisdiction. Name, address of complainant. Here you can mention. Age, you can mention here. If senior citizen, you will have to mention gender, contact number. Basically, you will have to give the detail of the complainant here in this column. Rest, if there are more than one complainant, you can give the detail in 5A or 5B. If you are filing a case on behalf of a company or proprietorship firm, so in 5A you can give the detail of proprietorship firm, because if it is a sole proprietor, above will be the sole proprietor in in 5, and in 5A you can give the detail of sole proprietorship firm. Name of the police station. Now, how you can conclude the name of the police station? The area where you are residing, the area where you are working for gain. This is my query. I'm not discussing, I'm not telling. This is my query. The area you are residing, you means that against whom the check is bounced. Supposingly, check आपकी favor में हुआ, आपका check bounce हुआ. Then the area where you are residing, the area where you are working for gain, or the area where the check was presented, or the area where the accused person is residing, or the area where the deal was done for which the check was given, against which the check was given, you can say.
एक्चुअली जहाँ पे कंसर्न पर्सन रिसाइड कर रहे हैं, लाइक कंपनी जहाँ पे जो रजिस्टर्ड एड्रेस है जहाँ पे कंपनी का.
Okay, next. I think someone was also telling something.
It's the place where the complainant is residing, because it should not be the hardship for the complainant, it should be the other way around.
Okay, tell me, can we make the jurisdiction where the check got bounced?
can, but if it is a third area, then better it should be the resident area of the complainant.
Okay. So the area which you are concluding as per act, you will have to get the police station of that particular area. Like if the area is Dwarka sector 10, then you will have to mention here Dwarka, because Dwarka sector 10 falls in the jurisdiction of Dwarka police station. If it is Pitampura, then you can mention Moria Enclave or Pitampura. If it is Shalimar Bagh, whatever be, you can mention here the name of police station. Any other information with respect to present case. Any other information. What kind of information we can mention here? If the check issued with regard to any kind of loan or any kind of transaction in the sense any agreement, any contract, whatever, you can give the detail here in this. Even otherwise, being lawyer, if we are getting a check as fee and that got bounced, we can mention here that this check was our fee check. Even we can give the detail of the case. So next will be
No, madam, before that, I just need to recheck whatever I answered, was it correct, or like is there any improvement to be done in that area of the police station?
pardon, sir. I'm not.
You had asked the area of police station.
I'll
I had
share you the
answered, like,
judgment. I'll share you the judgment in this regard. Everything will be clear to you.
thank you, ma'am.
Okay. It's not working. So we had done with we have done with address form, checklist 138, Wakalatnama, process fee form, memorandum of appearance. So now we will come to why it's not working. Okay, tell me, is someone aware about the form number 45, bail bond? What is bail bond?
In the local police station, which we need to fill up in non-cognizable offense, I believe.
Sir, first of all, I would like to tell you one thing. We were used to submit the bail bond in local police station, but now the local police has no power to get the bail bond. The only power, only right is with honorable court, not with the police. Police bail wala jo system tha, that has been abolished. And why it is abolished? Because when the courts see that corruption is high level because of police bail, so they thought it should be abolished.
मैम ये कब से ये abolished हुआ है?
I'm not really recollecting, but I think during COVID time, I think in 2021, I'll again give the detail.
Okay.
Priyanka, please note it down. Whatever we have to share with the participants. Priyanka, are you there? Okay, Banu, are you present there?
Yes, ma'am, I'm here.
Please note it down. Whatever
Yes,
we
ma'am.
have to share with the participants, like judgment of police station jurisdiction in 138. Second is when the police bail got abolished. And the third one, the PPT, some people were asking from me. Any other thing, whatever you want to get from my side, you can tell me.
Will we receive a certificate for the same thing, the class which we are doing?
Actually, this is not the certificate course, but we are planning very soon the certificate course. I'll discuss this thing after this training. I'm thinking too much about my upcoming generation for fresh advocates and final year students and otherwise other advocates. I'm thinking too much. So I'll arranging, you can say, certificate course also. But I'll disclose all these things after this training session. So be available here.
Certainly, ma'am.
Okay. So this is form number 45, which is for bail bond, or you can say surety bond. We can use it as surety bond as well as personal bond. So firstly, we will move to surety bond. When the court orders any accused to release him on bail for filing 20,000 or 10,000, whatever be the amount, for like surety, then we will have to fill this form. Here we have to mention the name of the court, name of the police station, next date of hearing, if applicable. What are the sections under which the accused has been booked, sent to jail on which date he was sent to jail. Last in this column, FIR number. What was the FIR number? So here, this para is for accused. We have to mention the detail of the accused. I, ABC, son of, DEF, resident of. This is a main thing. Residence of. This address should be taken from the police file. When he got arrested, police file or judicial file, when he got arrested, what address he had, the IO had noted, that particular address should be mentioned therein. Many times, we the lawyers are used to be mistaken. We are used to get Aadhaar card or any other document of the accused and used to fill as per that. Accordingly, the accused has to suffer because most of the time the address mentioned by the police officer in the judicial file or police file got different from his KYC documents. So police jail authorities are not used to release the accused person due to mismatch in address. So try to mention the address by taking the judicial file or police file. Here you will have to mention the detail of the offenses. Here it is mentioned police station for having have been detained without warrant by the officer in charge of police station. Here you will have to mention the name of police station, and here you will have to mention the or section under which your accused has been booked. Then you will have to mention here the amount which the court has awarded, like 10,000, 24,000, 50,000. You will have to mention here. Here you will have to mention the signature of the accused if he appears on the date of hearing and you are giving the bail bond on the particular date of hearing. If he is in JC and you are giving the bail bonds in his absence, then you can mention here in as bracket, accused is in JC. If accused is present before the court from JC, then you will have to get signature over here, but you will have to mention from JC. Present before the court from JC. If you are presenting the documents or surety bonds in his absence without any date of hearing, you will have to mention here the accused in JC. Then you don't have to get the signature of the accused person. This column is for surety. Name of surety, father name of surety, his address. Now, his address should be as per his KYCs. Hereby declare myself for above said Shri. Here the name of accused. For whom he is being surety, the name of the accused you will have to mention. That he shall attend the officer in charge of police station, whatever be the police station, or court of Shri. Here the name of the court you will have to mention. And again the amount, the date where you are when you are submitting, month, year. Here you will have to get the signature of surety. Upon above, here in above, you will have to get the signature of accused. If on the date of hearing you are presenting the documents, if not, just mention accused in JC. But here definitely for sure you will have to get the signature of the surety. As witness, you can put your signature yourself. Otherwise, you can get the signature of surety of family member, family members of the surety or family members of the accused. Now, this is affidavit. Affidavit is for on behalf of the surety, not of the accused, because the surety is undertaking to present the accused person on each and every date of hearing. That is why he has been the surety and he is submitting the affidavit before the court. Here we will mention the detail of the surety. Now, the deponent is a resident of the above said address and having his or her ration card. Here the court has changed Aadhaar card instead of ration card. So here we have to mention Aadhaar number, then election ID card number. Now, here the surety has to declare his relationship with the accused. The accused is brother, father, uncle, whatever of the deponent. Deponent is the surety. Who is deponent here? Who is surety is the deponent in the affidavit. So, accused is mentioned relationship. Deponent is deponent has full control over him. Deponent is saying the accused against whom I'm giving the surety, he is my relative, he is my brother, he is my cousin, he is my uncle, and I'm having full control over him. Why he is deposing? Because court need to be convinced that you are the person who can present him in the court. Okay. And capable to produce him before this honorable court. The deponent is working. Now the main point is that what kind of document you are producing before the court to fulfill the surety condition. If you are in government job or if you are in private job, whatever job, and you are submitting your salary slip before the court, then you can tick this column. The deponent is working as teacher or working as whatever, manager, branch manager, site manager, whatever the designation you can mention here, at name and name of the company or name of the firm or name of institute where you are working. TC number. What is TC number? The salary slip, if you are getting, there is a particular number that is called TC number. You will have to mention there. Earns rupees, as per salary slip, you have to mention the amount But supposingly, if the court has passed the order of 50,000 per month salary and the person is earning 30,000, he will not be able to submit this document. Salary should be, or salary slip should be above than the amount directed by the court to be submitted by the surety. If it will be lesser, then it will not be maintainable in the court. Court will reject the surety bonds. Next is, many times in my own cases, when I was a DLSA counsel, because you are well aware in legal aid, the person who are financially weak are used to come to the court to arrange for legal aid counsel. So how they could manage huge surety amounts? So many times we had convinced the court to release the accused on bail on with surety bond on household articles. So in that case, we have to tick this one. And we have to ask the surety, what is the total value of your articles, household articles? What are the articles and what is the value of those articles? We have to mention here. In this condition, what the court do? It will not release the accused or will not order to release the accused on immediate basis. The court pass the directions and direct the IO to go to the house of the surety, check the articles, prepare a list, and suggest the court the estimate value of the articles. Not only this, the IO is used to be directed. Yes, is there anyone? Please mute your mics, please. So, IOs are used to verify from the neighbor of the sureties as well whether the articles lying with the with this person are his own articles. In one of my case, what the surety had done, he came to me कि मैडम हमारे पास तो कुछ नहीं है, हमारे पास ये चीज है, तो आप इस पे जो है ना श्योरिटी करवा दो हमारी और हमारे लड़के को रिलीज करवा दो. Okay, I had filed the application, court passed the order. As per the court order, I suggested them that on such and such day, IO will come to you. We will check the articles at your home and give the report to the court. And after that report, the court will pass the order. They said, okay. On the same day, he arranged the second-hand furniture and things. And when the IO visited to his place of residence, he investigated in a neighbor. One of the person told, ये तो 2 दिन पहले ही तो इसके पास सामान आया है, हम तो हैरान थे कि इसके पास तो कुछ था नहीं, सामान कहाँ से आ गया. IO presented his report before the court, and when I went to court, then honorable court disclosed all the things. Okay, your lordship, whatever the honorable court deems fit in the interest of justice can pass the order. I don't have any objection. In that case, the court rejected the surety bonds and directed me to keep that particular accused in JC for 1 month more at least for misguiding the court. Who had misguided? Surety misguided, no? Indirectly, surety misguided. And who got suffered? Accused. So, whenever you are doing or you are presenting the household articles before the court, be assured the article must belong to the person who is surety and should be in the custody of the person.
Ma'am, one question here.
Yes, please.
Sorry to interrupt you.
It's
So,
okay.
in case of surety, as you mentioned, sometimes people keep their property as, I think, solvency certificate, they provide that. So, what in case, like, if that property is sold later on, like,
Here we are discussing about surety, not on personal bond. When we will discuss on the personal bond, and basically, if the person is insolvent, hello, hello.
yes, ma'am. Yes, ma'am.
Yes, if the person goes solvent or insolvent, whatever the terms and condition applicable, uh, we can go to the personal bond. That is the next topic to this one. When I will tell you about personal bonds and why we are used to go to personal bond. If the person is unable to arrange the surety and himself is unable to manage surety for self, so we are used to go on the personal bond. That is why the provision is there of of releasing the accused on personal bond.
Okay, ma'am. Thank you.
Okay. So next is the deponent is the owner of the immovable property. We can put the immovable property as surety, but the same condition, the court will take the original documents of your property in its custody till the final disposal of the case. So I would like to avoid immovable property as surety, but if there is no chance because we don't have any other thing and we have only our property to be submitted as surety, in that case again the court will direct the IO to investigate upon the property whether the property is in the name of the surety. If the report is okay, then court will pass the order and direct the surety to submit the original documents of the property. Next, this column 6 I will take later on. 3, 4, 5, now 7. If we don't have anything as ever, we can arrange an FDR of the amount mentioned by the court in the order, like 20,000, 50,000, whatever be. In any bank or in any post office, we can get an FDR of the amount or like amount. We can submit that. Number 8, and any vehicle, like you are having scooter, scooty, bike, car, you can also put that particular vehicle as a surety in the court. That doesn't mean you will have to give your vehicle in the court. You will have to submit the RC. Sometimes the court are used to get the original RC and punch that. Okay, so try कि RC की punching ना हो, because once it is punched, that particular surety will be in the eye of the court. Second time he will be allowed, but third time he will not be allowed as surety. So whatever the document we will keep as surety will be in the court file, judicial file, till the final disposal of the case, unless we will not release that particular surety. After before that, we have to change the surety. If during the pendency of the case your surety says कि मुझे अपनी surety वापस लेनी है, like मुझे मेरी गाड़ी पुरानी हो गई है, मुझे बेचनी है, या मुझे मेरी property बेचनी है, या मुझे मेरे घर पे तंगी चल रही है, मुझे FD तोड़वानी है, in that case what you are having in your hands, how you will help the surety? You will ask your accused person, your client, to arrange a fresh surety, you will file the application before the court for fresh surety and discharge of previous surety. By this way, you can do. And here you will get the signature of surety, who will be deponent at the time of affidavit. Here again, you will get the signature of the surety. But this affidavit is not required to be attested by either by oath commissioner or notary public. There is no requirement. So this was surety bond. Now, many times we have observed most of the persons are not able to arrange the surety, and only due to that reason they are kept behind the bars in routine. So in that case, what can we do? We can file an application for seeking release of accused on personal bond. Most of the time, the court is used to allow the application, but if there is a multiplicity of cases against the accused person, in that case, court will not allow. What are the personal bond? Only this column up to the details of accused person. We will have to fill up. This we will have to cross because we are not filing the surety bonds, and backside of affidavit again cross. Only accused detail and case detail we have to mention, and two sets of this particular documents of personal bond we will have to submit. One will be in the judicial file and another copy will send to jail where the accused person is kept. Two sets of this document will be submitted. Next is inspection form. Inspection form. When I started my practice in 2002-3, we were used to write down the inspection application with our own hands. But as of nowadays, we are getting the performance of inspection application. So here it is, I'm showing you. We have to mention the name of court where the case is pending. Here we have to mention the name of the, number of the case, means the number given by the court, suit number or petition number, whatever it is. The name of the parties. In case of FIR, you will have to mention here FIR number. In case of case number, you will have to mention the case number. Next date of hearing, you will have to mention here. But because sometimes files are not used to be traceable, so we have to mention here, I'm used to mention here last date of hearing as well, so that if the file is not traceable, the staff could easily trace with the last date of hearing. Because sometimes dates have not been updated in the cause list, or file have been put in old date of bundles. So it's better to avoid delay. You can mention here the last date of hearing. It is simply that above said matter is pending for adjudication. In civil matter, you can write down adjudication and determination. In criminal cases, you can write down that the above said matter is pending for trial before this honorable court, and the next date of hearing is whatever be the date. You can write down that the counsel for the whatever your party, plaintiff, petitioner, complainant, accused, whatever, you can write down. Again the same, whatever be the name, whatever be the name of party, you can write down here, put your signature. If the case is pending, you have to put the court fee of ₹5. And if it is decided, then you will have to put the court fee of ₹2 and submit it to the court. Court will allow it. You will go to the concerned staff of the court with allowed application, and you can request my application is allowed and get me the file so that I can inspect it. Last but not the least, in the inspection application, when you will inspect the application, you will have to put your signature here by mentioning file inspected. You will have to mention a particular time. Supposingly you have started inspecting your file by 3 o'clock and you stopped inspecting by 5 o'clock. Then you will have to mention file inspected between 3 p.m. to 5 p.m. by your name, your enrollment number, and your signature. You will have to mention your inspection date. Don't forget to mention the inspection date. Okay. I think everything is getting clear to you.
Yes, madam.
Yes, ma'am.
Thank you. This is the index form. At the initial stage of my practice, we were used to attach this form before the list of documents and the case proceedings. Like first is petition, then petition under section so and so, interim application under section so and so, along with the sporting affidavit. Then again we were used to file index wherein we were used to mention the list of documents. But nowadays we are used to do single index on the face of the petition or case, where in column number 1 we are used to mention name of parties, and second number we are used to mention the detail of the case or the detail of the petition. Here we are mentioning here court fees. On face of the petition, what how much amount court fee you have affixed, total pages of the petition. Nowadays what I am doing, the documents which are used to be annexed, I'm used to mention here number 3, number 4, number 5, like annexed PW1/A. What is annexed PW1/A? Detail, court fees not applicable, pages. In continuity, I'm used to do. Thereafter, interlocutory application, because the documents which we are attaching is related to the main petition. After completion of the documents, attach interlocutory application along with sporting affidavit. Then at last, wakalatnama. Here you will have to put your signatures and put this document just on the face of the petition, complaint, whatever be, or written statement, whatever. So these were the legal performers. So we had concluded today dressing sense, client dealing, file management, court presentation, diary management, legal performers. I hope all of you could better understand, because I tried my level best. And if there is any kind of discrepancy, you can suggest me. Suggestions are awaited.
Thank you, ma'am. Thank you very much. The way you explain,
Most
we
welcome.
are very lucky to get the lecture the way you had given the practical knowledge.
Thank you. But I
Yeah,
would
God
like,
bless you.
अगर आप लोग कुछ मुझे suggest करें कि everything you used to say कि हाँ, it was nice, it was good, but I want आप लोग कुछ कमी निकालें कि कमी कहाँ है, so that I next time I can improve it.
See, ma'am, at present my age is 55. Recently, in the 21, I completed my law LLB. So I'm
Okay.
trying to get a practical practice, but due to my, I don't know, it's my bad luck. I'm not getting any cases, nor how can I explain you? I want some practical knowledge so that I personally should go and get the everything. In the
Okay.
group, I got this message. So even though today Eid is there, so I attended this lecture because from my childhood, I want to do this practice. I want to be a good lawyer. So my husband has supported me. So I taken the admission in law college at the age of 50 and I completed by 53.
That's nice, and wish you all the
Yeah.
very best for your
Thank you,
future.
ma'am. Thank you very much. God bless you.
Thank you.
Yeah.
So during the training, Abhishek was suggesting something. So let us discuss, Abhishek.
Yes, sir.
And if anyone is also want to suggest something or with regard to training, suggestions are most of it. I can request you. Everyone is welcome to give me the suggestions.
Madam, I have one suggestion.
Yes.
Nowadays, we find that a lot of things has gone online. For example, the filing process is pretty much online in a lot of states, as well as there are apps where you can see the status of the case, and a lot of things have gone online, right? Like if you could also just like how with the changing times and maybe like a lot of the things like the file management, like physical file management may not be more relevant anymore. And so in your sessions, if you could bring in some of the newer things that have taken place, some of the newer developments and how they are replacing some of the older things, then I think that would be a great thing.
Yes, I can understand your point, but my concern is only that the fresh lawyers, the fresh law graduates who are not aware about the basics of court practice, until unless they will not aware about the basic of the court practice physically, then it will be tough for them to learn online and all. Okay. No doubt, as of now, in district court, Supreme Court, even in consumer courts, everything is going online. We will definitely work on this, and we will provide the training session on this as well. But first, we are used to say, no, before coming to first class, we are used to go in nursery and UKG, LKG, like that. So we are doing like this, step by step we are going. So in the near future, we will also arrange sessions, how to deal with online cases and how to file online cases, all that.
Thank you, madam.
Yep, most welcome.
I would request, ma'am, if it would be certificate courses, either it would be paid or whatever it would be. So that would be beneficial for fresh lawyers. Actually, I am in final year, but I am not attending a student. I do not used to go to the colleges because of my personal work. I am owning a company. So that's the reason behind I do not have time to go to the colleges. But this practical knowledge, as you shared your information with us, that is really valuable for us, and I really appreciate for the same thing. So I would request if you are planning to run any certificate courses that would be paid, that also would be very much beneficial for us to learn lots of things, because nobody used to teach such information in details like as you shared with us.
Thank you, Abhishek, first of all, giving such an appreciation for this Knkr, the HL Memorial Trust, which has think about the law students and fresh law graduates. So again, my reply is that we are already working on this particular area you are suggesting. Firstly, we have prepared for a 1 day course, 1 day training course, that is a physical mode. And thereafter, we had prepared one more course that is called Fundamentals of Drafting. That is also 1 or 2 days course. And again, we are arranging for the, you can say, drafting, wherein we can take all kind of drafting like contracts, agreements, writs, complaint, petition, written statement, notices, every kind of that is under process. It will take little bit time, but as far as 1 day or 2 days courses are concerned, certificate courses are concerned, very soon we are launching that, and you will get the information with regard to that. And hope like this online course, you will give your love to our physical mode courses as well.
Certainly. And also the paralegal work courses would be also appreciable, like how to
Yes,
get the
yes,
paralegal jobs.
we are into that line only because the trust is working for general people and fresh lawyers as well. Because I know very well the fresh lawyers are not used to get work as soon as they pass out. So we can arrange, and we are arranging for fresh lawyers as well.
Okay.
Any other one? Okay, tell me one more thing. I think 20 people are there. So anyone is interested in post training?
Offline mode or online?
I think in both mode, post online, offline. But because if you go online, then it will take a long time. Weekend classes, 3 hours at least for Saturday, Sunday. It will take approximately 1 month. And if you will get it physically, then at least 3 days, 9 to 5, 10 to 5.
Okay, and where is the location, ma'am?
Location will be decided later on. Till yet, we have not decided the location. Yes, Mr. Ankit Nema, please.
Yes, ma'am. For the online one, like I'll be interested, but if you can share more details, because yeah.
Okay, we are planning. So whenever it will be planned, I think hopefully I will start it. We will start it in the month of May. Hopefully, but my main concern was that you will want to get post first or mediation first.
Sorry, which one? Mediation and?
Mediation training.
No, mediation and other one?
Mediation and post protection of women from sexual
We should go
harassment.
for mediation first. Actually, today the session was excellent, but we should go for the mediation.
Okay.
And if
So-
possible, then you can keep any timing in the evening, post 6 p.m.
Okay. But one thing I want to tell you, for mediation, it is not possible to get the training on virtual mode, because
Okay.
mediation training, at least it is of 40 hours training, and it
Definitely.
will, yes. So it will be held physically.
Not an issue.
Okay. Any other one?
Ready, ma'am.
Any suggestion? So
How will you, sorry, how will you decide,
yes.
like now I reside in Mumbai and you are taking
Okay.
classes from Delhi. So taking physical classes, how is it possible?
Sir, you are not audible properly.
I said that I reside in Mumbai and you are taking classes from Delhi.
Yes.
So going physical classes, how is it possible?
we can do one thing. We can do one thing. If you can support us, then we can arrange the classes in Mumbai as well. If you can arrange many much more candidates there to attend the program, we can arrange Mumbai in itself. We are
Yeah,
used to come
this
throughout
training
India.
was really worth that I can share with friends and my other
Thank you.
college
Thanks a
teams.
lot. Thanks a
Yeah,
lot.
yeah.
Okay, someone is who is Redmi Note 7? Please change it and write down your name. I got the message. We are from Telangana. Shivani, okay. Okay, Shivani. So, do you need training in Telangana? So same request is for you. As just now I have stated, if you want physical training and you want the training to be in Telangana, then if you can arrange other candidates along with you, then we are ready to come to Telangana.
What should be the strength to have the physical classes? Minimum.
Pardon?
Minimum
Minimum
strength.
strength, 20 to 30.
That's fine.
Otherwise, in Delhi NCR, we can provide this training, this foundation course training free of cost if the college provide its own auditorium. College or university provide its own auditorium for the students. Again, we can give the free training physically.
It will be at par with that mood court, such atmosphere, everything you need.
Yes, yes. We will arrange everything there because these things are not possible on virtual mode.
Madam, and if the college provides this is the auditorium and they take care of the stay and travel, then is it possible to have the
No,
free
no, no.
lectures for the students?
Just listen to me. Just listen to me. I stated this for this foundation course, which I have given the training to you today. This is the extended version. Last time we were not ready with the PPT, which we had shown to you on the dressing sense. So just with words, we given the training. But last night we had prepared the PPT to make all of you understand in a good way. So we can extend this training foundation course only for 2 or 3 hours maximum in auditorium, not full day, no residential or stay like that. And if we are going for the training for 1 day, 2 day, then we will arrange and that will be paid. Because if we are arranging for you, then for sure the accommodation we will have to pay for accommodation and accommodation, tea or lunch, dinner, whatever be there. Accordingly, we can manage.
Okay,
And
madam.
we are otherwise arranging in other colleges, even my own university from where I had passed out. They are also ready to give me their auditorium for the current students. Because I want to tell you something about myself. Actually, I think now because session is closed, so I should stop the recording.